The Waters of the U.S. rule has caused a considerable amount of controversy in agriculture for many years. In recent months, the regulatory definition has popped back up as plaintiffs claim the rule violates the Clean Water Act. Joining us for an update right now, Roger McEowen with the Washburn University School of Law in Topeka, Kansas. Roger, thanks a lot for joining us. Let's start with some background on this rule.
Yeah, thanks, John. Good to be visiting with you this morning. This is a big deal for agriculture, and we do have some recent developments on this. But, of course, this goes back to the proposed rule under the prior administration that defined tributaries to waters of the United States rather broadly to include natural and man-made waters and wetlands and lakes and ponds and canals and streams and ditches if they contributed flow either directly or indirectly to interstate waters, irrespective of whether those waters continuously existed or had any connection to what we would traditionally think of as a water of the United States, a navigable waterway. And they also had a very expansive definition of adjacency in that rule. And, of course, that upset a lot of agricultural interests in anybody that basically has rural land. Well, what's happened recently is that we've had another court decision by a federal court in Georgia that has entered a preliminary injunction against the rule, preventing that from being implemented in 11 states, and that's in addition to another court that had previously entered an injunction barring the implementation of the rule in 13 states. So it's currently cannot be put in place and enforced in 24 states across the country, and a lot of those are primarily ag states.
Well, can you give us an update then on the Sixth Circuit litigation and the jurisdiction issue that goes along with that then?
Yeah, the cases I was just mentioning are federal district court cases, but the Sixth Circuit in late 2015, they issued a nationwide injunction barring the rule from being enforced anywhere in the U.S. Well, that got challenged basically on the issue of jurisdiction. Is this a matter for the federal appellate courts, such as the Sixth Circuit, or is this a matter for each of the federal district courts to deal with as they're presented with the issue? The Sixth Circuit said, well, we can take it. It's with the appellate courts. The Supreme Court reviewed that decision and said, no, it's the district courts that deal with this. So jurisdiction is in the district courts, and so this would have to be litigated on a case-by-case basis. Well, that's not the end of the story, because President Trump, when he took office, directed the Corps of Engineers and the EPA to issue a notice of proposed rulemaking to clarify this and narrow the scope of the reach of the rule. And the deadline period is today for people to submit comments by going to the Corps of Engineers, the EPA's page called the Waters of the United States, and submit their comments. Thousands upon thousands of comments have been submitted with respect to this new proposed rule that would narrow the jurisdiction. But where we're at now in the courts is jurisdictions with the district courts. We've got an injunction in place in 24 states, and a proposed rule is being worked on that would narrow the scope of WOTUS. So that's where we stand as of today, John.
Roger McEowen with the Washburn University School of Law. Thank you very much, Counselor. Appreciate you joining us.